Kיtzad, העדים, Daf Zion, sponsored for a bracha of Hatzlacha for Chaim ben Avram. We begin with the Mishnah. This Mishnah explains laws concerning fugitives of a court. Number one who escaped a court that sentenced him if recaptured by that court is not retried. Two witnesses testify so-and-so was sentenced to death in some court is executed. A question. These two statements contradict. Inferred from the first statement is if the accused is recaptured by a different court, he is retried. Whereas inferred from the second statement is does not matter which court accused him. He is not retried. The answer. Abai explains one who escaped a court located outside Eretz Yisrael before his execution, who was subsequently recaptured by it, when located in Eretz Yisrael, is not retried because the merit of Eretz Yisrael will not favor him in the same court. However, if recaptured by a different court in Eretz Yisrael, his case is retried because the merit of Eretz Yisrael may influence the court's judgment in his favor. Second statement refers to witnesses who testified in a court outside Eretz Yisrael. One who receives smicha in Eretz Yisrael can sit on a court of 23 in Chutz La'aretz to judge capital crimes, long as the Sanhedrin Hagadol sits in the temple. A verse states, "V'hayu lachem chukas mishpat adorosechem b'chol moshvosechem," in all your dwellings. However, outside Eretz Yisrael, courts are required only in every province, where in Eretz Yisrael the Torah requires bisharecha, a court of 23 in every city. The Tanna Kama holds a court of 23 where one or more defendants are executed during a 7-year period is considered a destructive court, either not aware of the legal intricacies judging capital cases or unwilling to exert enough effort to exonerate the defendant. Rabbi Elazar ben Azariah states 1 in 70 years. The Gemara is not certain if 1 in 70 is proper, more than 1 is destructive, or less than 1 in 70 years is proper. Rabbi Akiva and Rabbi Tarfon stated had they sat on the Sanhedrin during the time capital crimes were tried, not one defendant would have been executed. Where the evidence against the murderer was compelling, they would have killed him indirectly in a kippah. Their interrogations in murder cases would require the witnesses know the victim was not a treifa. In cases of adultery, they would require witnessing actual penetration. Mishum Gamliel held that form of punishment is not a sufficient deterrent. Shmuel holds it suffices for the witnesses to testify the couple behaved like adulterers. Perek Elu Hein Hagolin. We begin with the Mishnah. This Mishnah discusses those entitled to exile for inadvertent murder. One who dropped a plastering roller, barrel, or one fell from a ladder on a bystander, accidentally killing him, are exiled for inadvertent murder. The reason. The Gemara derives this from the term vayapel olav, that one is exiled for killing with an object in downward motion, descending a ladder or lowering an object. This is because gravity exerts a downward force on objects, requiring greater care when lowering them. However, one is not exiled if while drawing the roller upward it slipped, or while raising the barrel the rope tore, or while climbing the ladder he fell. An upward motion opposes the force of gravity, diminishing the likelihood of objects falling. Question. One who climbed up a ladder did not fall, but dislodged a rung that killed. Did the victim die the result of an upward or downward motion? The answer. Number 1. Rabbi Yochanan holds its motion is downward, even though it supports the upward motion of the climber. Rabbi Avoh disagrees. He holds the general statement of the Mishnah, if he killed not in a downward motion, excludes this case. Number 2. Its motion is downward when eaten by termites, causing it to bend before being dislodged. However, when not eaten, its motion is upward. Number 3, its motion is downward when loosely attached, upward when firmly attached. 2 terms describe one liable to exile. Shogeg excludes deliberate murder. Bivli das excludes intentional murder. Rav explains the second term, Bivli das, excludes Omer Mutter. One who claims murder is permitted. He cannot atone for his crime by being exiled because his action was karav lemezid, close to intentional, allowing himself to remain ignorant of the law. Abai is diametrically opposed to Rava. He holds Omer Mutter is karav lonis. One who believes that murder is permitted is guiltless Both opinions exempt Ha'omer Mutter. However, Rava holds he is a criminal susceptible to the vengeance of the Goel Adam, whereas Abaye holds the Goel Adam would be liable for murder. Gemara, based on terms of a verse describing one exiled, teaches other qualifications for Golus. Number 1, im befeta, he is exiled when the victim is so near that he could not avoid contact. 2, below Eva, he is exiled when there is no history of hatred, ignoring the victim for 3 days. Number 3, hadafo, he is exiled if he pushed the victim, not considered accidental or close to deliberate. Number 4, ohishlich alav, he is exiled for downward motion, assisting his upward motion. Number 5, below tzdiya, he is exiled if the object hit the victim unintentionally where he aimed. Number 6, bashelo tzada, the object hit the victim at the distance he intended to throw. Number 7, asher yavos reo bayar, he is exiled if the victim was killed in a place both permitted to be. If you're enjoying Daf 5, please click on the link below, subscribe, and become a sponsor. Thank you.